This is part 2 of the lecture on ownership, transfer, and description of real property. I am Chris Rouse, your instructor. We're in the same class, East Central Community College. This is spring of 2014, and we're still discussing Chapter 3 of Brown's Boundary and Legal Control and Legal Principles. So, remember that title is the means or authority by which one justifies legal possession of property. It is not ownership, only evidence of ownership. So when we talk about title, remember title is that bundle that holds all of the rights together, and title is defined by a boundary of some kind. And we talked about the macro boundaries and the micro boundaries and how those come into play with title. Title is basically the document or statement that defines the claim of ownership. Like all evidence, it's one piece that gives probable ownership. Now, title can be obtained in many ways, but it's typically obtained through a deed or a private grant of some kind. Now, these are some of the sources of title from your textbook. Some of these are pretty interesting, like I'll let you read them. But conquest or by war, and the ultimate peace treaty. A lot of the land that was obtained by the United States early in our history was by conquest and war and peace treaty. Some of the other ones, will by a deceased person. That one happens quite often. Title by descent of a deceased person. So if you're a child of a deceased person but there was no will, you can obtain title by the deceasing of your parents or deceasing of a spouse or things like that. Involuntary alienation or bankruptcy or foreclosure. That's another one that's kind of interesting. Eminent domain. We talked about that one. Escheat refers that it's reverting back to the state's ownership. Dedication, you can dedicate land for like a church or some other public or private use. Other sources of title include at law, courts granting title to accreted lands, etc. And we'll talk about what accretion and avulsion is later in the semester. Parole guaranteeing under certain strict requirements. I know of some titles to land that are defined based on this land can be owned and used as long as the person owning and using it lives there for perpetuity. You can have a grandfather that has land, gives it to his grandchildren, but they can own it and do with it as they please as long as they live on it. But as soon as they go to move from it, it falls into someone else's hands. That happens. Another one down at the bottom that was interesting. By prior appropriation or the use of moving water when a boundary. When a boundary is defined by moving water and that boundary moves, it's also known as prior appropriation to make sure that it goes back to the way it was. So these are just some interesting different sources of title, all from your book once again, and you can kind of read through those. We're not going to go through the descriptions, the principles of descriptions, which are all part of Chapter 3. Now, I hope you've noticed something in my lectures that we look at these principles a lot. And it's because these principles are the way the book defines how to look at different things. So please make sure that you read the principles. I'm going to read them. Here's principles 1, 2, and 3, 4, 5, and 6. And principle 7. And we're going to read them each individually, and then we're going to talk about them. So principle 1. One who grants title to property to a second person, that grantor can grant no more interest than that which is owned at the time of conveyance, which makes perfect sense. I can't convey something that I don't own. That's like me walking out into a parking lot and saying, all right, do you want this Hummer? I'll give it to you for $10. Well, if I don't own the Hummer, then me giving it to you really doesn't make sense. Same thing with land. I cannot convey title to something I do not own or have interest in. Okay? So this covers the concept the person can't just give something they don't own. For instance, let's say that A conveyed the timber rights to his parcel to ABC Timber Company in 1998 for a period of 25 years. And this is very common. You give them a year period and the company can use it as they please, gathering timber. Well, then A sells and conveys the parcel to B. So he sold the land. But he can't convey the timber rights because guess what? ABC Timber Company has those rights. And until 2023, he can't do anything about it. Kind of funny. In this case, a quitclaim deed would be used if not all the rights are transferred in conveyance. And we'll discuss this later in this lecture, but quitclaim deeds are used to basically give away what you own, the interest in the title that you have, to someone else. But this principle is very important, which makes you think about when you buy land, you want to make sure that whoever you're buying it from actually owns the land. That's a very, very important part. Principle 2, title insurance states only that if a defect is found in the title that is insured, the insurer will either defend the title in court or will make good the value of loss. Now, this is not like your typical insurance. Like your auto insurance, you pay it so that in case you're in an accident, something happens, the insurance company will take care of your expenses. In this case, what title insurance does is it protects the grantee, which is the person buying the land, if there's a problem with the title. So, for instance, if let's say that you buy a piece of land and there's a problem with who owned it last, they didn't pay their taxes or they didn't pay off their mortgage when they tried to sell it. If you don't have title insurance, all those expenses could fall back on you. And so it's a good idea to get title insurance if you're purchasing a parcel of property. Even if it's from an acquaintance or even, I hate to say it, from family. Because if you're planning on starting your life off and buying some property, title insurance is one of the best things you can do. A personal example. When I bought property recently, about 2 years ago, in Newton County, I bought a piece of land, about 3.5 acres, and I didn't know much about the guy who bought it from, but they asked if I wanted title insurance, and I said absolutely, because I believe that's important. Well, they found some issue where the land was sold by people that didn't own the land. Going back to principle 1. In that case, if I had just purchased the land, I may not have actually had title to the land because it wasn't a clean title to begin with. We got it all fixed, we got it worked out, and because of the title insurance, they helped me and fixed it before we had any other problems. It was very much worth the money that was put into it. Many mortgage companies require that kind of insurance to protect their interest in the property. A mortgage company doesn't like anything worse than something being wrong with the title, because that means that even their interest in the property is voided or changed. Principle 3. A land description in a deed conveys only the interest that the wording, terminology, and survey measurements that are depicted at the time when the survey was conducted and the description was written. Words, calls, monuments, corners, all these things are important to the description of the boundary. But they are written back in the past, and they should all be written with a clear intent and definition of measurements, monuments, methods, because of the passing of time, because over time things change. For instance, if you have a call for a fence corner, well, what if that fence corner is pulled up or the fence is torn down? What if there's no evidence of that left? And so it kind of becomes a problem then if the land description is not written in a very clear and concise way and consideration is put into for the passing of time. Many times, in many cases in state statutes, you're required to write a description that will legally be able to stand for at least 50 years. The concept there is that the passing of time won't affect the land as much, and probably every 50 years land will change hands and be surveyed. As time goes by, monuments can be destroyed or lost, like I said, and it's the job of the retracing surveyor then to use the description to locate the intended boundary and do the best they can to then find the extent of the interest. But remember, a description just conveys the interest that all of the wording and measurements define. Once again, a boundary is the extent of interest, the extent of title, and we're talking about granting title. This is very much important. Principle 4. To be absolutely controlling in a resurvey or retracement, a corner and its monumentation must be called for in the original description. Now let me talk about what controlling means. Controlling means that it holds from the previous boundary survey. A good description will call for the monuments by their type, what is it made out of, a direction and distance from each other, maybe even some witness trees. So a controlling monument or a controlling corner must be called for in the description, and it must be called for in a way that it can be retraced easily. If a corner is not called for in the description, the surveyor cannot be absolutely sure that it is controlling in the survey. There might be a lot of corners out there, but without understanding which one controls, the surveyor may not know. Many early surveys did not call for specific monuments, and this can cause serious headaches. Many of your earlier surveys, they just go distance and direction, and that's it. They don't say that it was an iron pin or a 2-inch iron pipe or a bedpost or a wooden fence post. Or they don't say things like that. And so as a surveyor, I'm going to encourage you to, when you write a legal description, put down as much information as you possibly can. You're required to locate all possible monuments and place them on the plat. That's required. But also call up what they are. But be careful, because many uncalled monuments can also clutter up a plat. Excuse me. So you really want to make sure that you identify all the information, but you want to do it in such a way so that we can make sure that it is controlling or it's not controlling in the survey. Principle 5. The unit of measurement indicated in the description excuse me, is the unit of measurement used at the time of the survey or when the description was written, and should be the reference measurements from which the survey should refer. This means that some surveys may not use units that are common today, and this happens a lot in Mississippi. But nevertheless, we're still required to convert and use those measurements. And you say, why? Well, this kind of comes back to the concept of original surveys being unchangeable. Yes, the equipment that we have today is much more advanced. Yes, we can get a lot closer than the people of yesteryear. But changing boundaries is a legal issue and not a survey issue. So we're not going to change anything, but we're going to instead retrace and follow in the footsteps. And you can't follow in the footsteps of someone unless you've walked in their shoes. Yeah, you can write that one down. Put it on your wall or something. It's pretty awesome. For example, a survey could be described in chains. And I hope all of you know what a chain is. Gunner's chain, 66 feet long. You as a surveyor need to understand the conversions for these units and the errors that can arise from the collection of these measurements. You may find a line that was a mile long, measured with a chain, and you find out that it's actually 10 feet longer than it should be. Could have been an old chain that was used. And if you can identify the reasoning behind the way it was done, then you can maybe make a case for a change in the survey. Exact and repeatable conversion methods should be used to ensure the integrity of the data. Make sure that you don't just make something up, but that you do it repeatably and with intentional methodology. I mean, your methodology needs to just be as intentional as possible. Principle number 6. Distances cited in modern descriptions are presumed to be along what we call a horizontal straight line. This is a line that is perpendicular to gravity. That's kind of the term that we use. Distances in early descriptions may or may not be presumed to be along a straight line. The contrary to this has to be proved. Many early meets and bounds surveys have been measured by the land or using slope distance, and this can cause some serious issues, because when we talk about horizontal measurement, we're really talking about a defined distance that does not take into account terrain, but rather it is a precise boundary extent measurement. But if you already have an early description, you really want to check and see if the terrain is rough in that region, because it can make a difference in what you find and what was recorded originally. If field notes are available, it's a good idea to read these notes and determine the method of measurement. Some of the original surveyors will write notes about how they broke the chain, or how they did measurements differently because of the terrain, or they used a shorter chain or a longer chain. And this information could clue you into the validity of those recorded measurements. And it's really important to know where you came from in that, because that's really the whole concept then of surveying and retracing those steps and following in those steps. And then number 7, talking about magnetic bearings. One can presume that when a magnetic bearing is indicated in a description, the declination to be applied for the correction to a true bearing is the declination in effect at the time the description was written, or when the survey was made. Now, basically what this says is magnetic direction changes. All of you that have been in my program know that the magnetic pole, North Pole, changes. It moves every year. You can look it up on the internet and watch it move. It's crazy how much it can move in some years. Because it moves, we have to do something called declination. We're going to assume that that magnetic direction taken in the 1830s was done with a declinated magnetic compass. But we got to go back and make sure. Since the magnetic pole moves from year to year, it's important to realize that compasses had to be adjusted. And then it's also important now to go back, and you can go back on the NGS website and look at magnetic declination from the 1830s. They've calculated it all the way back, so you can see that, and then you can retrace using a compass-directed description with the proper declination. You'll also be able to then see how they measured distances as well, because you'll understand the bearings that they used. And these values can save you a lot of time and effort when you're retracing, because you can find things and information. Doesn't make sense at first, but the more deeper you dig and the more you look into how they did the original survey, the more information that you can gain. So, some methods of voluntary transfer. And this kind of switches gears a little bit, but comes back to the whole title and the ownership transfer thing. Today's common methods of voluntary transfer are usually written documents. They're either deeds or wills, and those are the two major methods. Under deeds, we got 4 types: grant, quitclaim, warranty, and easement. And then wills are it's a general term that we're going to talk about. A will includes the wishes of the deceased party to whom property will descend to. These are legal in nature and rarely involve surveyors, unless there's an issue with the boundary or if the will calls for a separation of property that has not been done yet. But rarely do these involve surveyors. Talking about the different types of deeds, a grant deed ensures that previous to or at the time of conveyance, the grantor has not conveyed any rights to another person, and the land is free from encumbrances unless otherwise stated. Basically, he's saying, look, I am ensuring myself that I haven't sold this land to anyone else, haven't given any rights to anyone else, and as far as I know, it's free from encumbrances. It's kind of based on a man's word. I give you my word that it's okay. You don't see a whole lot of those. Not anymore. Many of those were done early in the history of the U.S. A quitclaim deed, very popular, very common. Basically, it's a release of currently possessed rights. If I have rights to a piece of property and I want to convey them to you, I use a quitclaim deed. Boom! But the problem is, if someone only has a half interest, then that's the only interest that can be conveyed. For instance, quitclaims can only be used to transfer rights of ownership except for mineral and timber rights. Those are used by mineral or timber deeds. But, for instance, if I have landowner A, who has given his timber rights to ABC Land Company, and then I sell with a quitclaim deed to B, B's going to get kind of the raw end of the shaft because B is getting all the rights to the land except for the timber, because A's already conveyed that. And so that's what a quitclaim deed does, is it quickly and releases all the currently possessed rights. Whatever I have, you've got now. But that may not be all the rights. And so quitclaim is one of those things that you can do, and they're very popular, very cheap, but you got to be very careful what you get. The best one out of all of these is the warranty deed. This assures the grantee, based on the grantor and also based on the grantor's maybe business or company, that they have good title without a lien or an encumbrance, no mortgage, no nothing like that. And if there's a problem with the title, then the grantor will either go to court for the missing rights or title issue to guarantee the title for the grantee. Basically, it's like a grant deed, except I'm saying if something is wrong, we're going to fix it. Anytime you buy land, you really want to get a warranty deed. Warranty deeds also include title insurance. Easement deeds. This grants rights to another group or person for a specific use of the property. This may be used for utilities or highway projects, and this deed does not ensure any title really, but rights are defined in that document. So for instance, if I want fiber optic cable brought to my house, I may have to have an easement deed so that AT&T can bring fiber optic cable up to my house. Well, that's really important because I want DSL. But they also want to know the extents of their land and their easement so they can bring the utility onto my property. This goes with gas and water companies and other companies as well. Power companies do a lot of easement deeds. They just want a strip of land that they can move their utility along, and so that's where an easement deed comes into play. And you'll see these 4 types and many others. There's deeds of trust. There's which involve mortgages. There's other deeds, mineral rights deeds, and oil rights deeds, and gas deeds, and timber deeds, and agricultural deeds, but these are the 4 major types of deeds. Now, when we talk about involuntary transfer, those were voluntary. Those were deeds and wills. Involuntary is where land is basically given up for one reason or the other. Bankruptcies, foreclosures, seizure of property under the Fifth Amendment, are all considered involuntary transfers of title. These are typically because the failure of a contract, for instance, in the case of a foreclosure or bankruptcy, or some kind of illegal activity. Now, all of these are legal in nature and do not directly affect the surveyor, but you will come across some of these if you survey for any period of time. I was recently doing a retracement on a parcel of property, and I was researching it in the courthouse and found out that in 1998 was the oldest deed that I could find, and I couldn't find who it came from or went from. Researched a little further back, found out that there was a foreclosure on the house in 1998, and it came from another person. And once I found that person's name, I could keep going back. Had I not thought about the foreclosure deal and looking at a different type of deed of trust, I would have had a hard time finding the title for the land and retracing it back. So it's important for you to know about these things, but once again, we don't make the call on what's a bankruptcy or foreclosure. Under the RICO statutes, the Racketeer, Influenced, and Corrupt Organization statutes, property can be seized and turned over to the state or federal government for crimes. If you're growing marijuana on your property and they catch you growing marijuana, they can take the property and then turn around and sell it and involuntary transfer your land without your permission. Yeah, because it's under a RICO case. This involves not just drugs, but other illegal activity, money laundering, anything like that. Anything that's going to be under the RICO statutes, they can just take the land and then turn around and sell it. It's an amazing thing. All right, so next week we'll have Chapter 4 quiz, boundaries and law and presumptions. We need to read Chapter 4. We're reviewing for Exam 1 that is already posted. You'll be given a proctored exam between February 10th and February 14th. You must make arrangements with your local e-learning department to take this exam. It's very important that you do that, okay? And if you're at East Central and you want to sign up, you click there on Legal Principles of Surveying to schedule that proctored test at East Central. It's important to do it ahead of time and to give at least 24 hours before you want to take the exam. You don't want to just hurry up one day and call them and say, I'll be there in 2 hours. That's really not a way to do it. So make sure that you have called ahead and set up your time for the exam. Hope you have a great week. Hope you've enjoyed this lecture, and we'll have more lectures to come.